This channel does not promote any violent, harmful, or illegal activities. All content provided by this channel is meant for an educational purpose only.
Why you have filed this writ petition on 3rd of May 2025 after 3 years?
Because of that, the RTI application. I made the RTI application,
but you could
first,
have waited
then SPIO, then first appeal, then SIC. Thereafter I came.
RTI application could
And not only that, I
Appointment?
2017.
but then published the list in the year 2022. But yes, it is annexed with merit petition.
Don't shout, Mr. Shamin. Before this court, please don't shout. You cannot outshout this court.
Yes.
Please be polite before this court while making submission. We know how to tackle this issue, this kind of attitude before this court.
Might be this is due to my.
Don't transgress your limit. Answer appropriately before this court. Be polite before this court. You are before this high court. Don't transgress your limit. Why you are shouting? It's a market. What do you think? That by shouting you will get an order?
It's my voice. I can what can I do, Malad? Due to mic, Malad, it might be, Malad. That's my voice. So what can I do? I never been.
Yes. What do you want to submit? Tell me.
Malad, may I submit, Malad? This is regarding 2016 selection process. In the 2016 selection process, board never published a patent. That's my concept. In the year 2020, board published a list in pursuance of the court order. When I see the court order of this list, it is published in the year 2020 on 28 November 2020. Very next day,
28 November 2022, what happened?
Board published a list
In connection with 2017 selection process.
2016 selection process.
But 2016 selection process was required to be completed within a certain time.
Yes.
While list was published in 20, he will become an ineligible candidate.
No. In the year 2016, both trained and untrained, both are
ultimately, if the appeal of the board is dismissed, therefore the right of untrained candidate goes.
No.
Because the trial court has decided not to consider untrained candidate.
No. That is not contested. Trial court decided if we go through the Priyanka Noskar judgment. Trial court says there are some irregularities and illegalities. What is the illegalities? They are not hold an illegality. What is the illegalities? They are not hold the aptitude test. That is the trial court condition, and there are other corruption also. If my lord not whether in the 2016 selection process what type of illegalities is there, my lord have to go through the Priyanka Noskar judgment. If my lord wants to go through, because of that, in Priyanka Noskar says there are corruption and there are also that the aptitude test is not hold. That's why, my lord, the whole untrained portion goes, my lord, and if against that order, my lord, appeal paper and it went up to the Supreme Court. And Supreme Court remanded it back, and that order till that is the stay. My right, even suppose, my lord, for the argument's sake, suppose, my lord, the Priyanka Noskar goes, suppose, then also my petition will survive. Why I say so? Because of that, my cause of action arose due to the list published by the board. Number one. Number two is that in the after expiry of the panel, board in pursuance of the court order published that list.
Whether your name featured in the list?
No, not obvious. Because of that, due to less meritorious candidate. What is my case? My case is that less meritorious candidate got appointment because their name is featured. That's my case altogether. And visualize it. My case is that the less meritorious candidate give appointment, although I am a more meritorious candidate, I not get appointment.
But if you are an untrained candidate, where is the scope of less merit and more merit?
Obviously. Suppose, Madam, Priyanka has two possibilities. Either Priyanka Noskar will survive or not survive. Suppose for the second argument, Priyanka Noskar will not survive. then also my case will survive.
How? Being an untrained candidate, where is the scope?
Because in the year 2016 selection process, kindly 2016 selection process, trained and untrained.
If untrained candidates cannot be considered by the dint of the order of the Honorable Division Bench, if the order is passed, in that event, where is the scope of untrained,
Out of
untrained candidate?
May I give, out of 42,949 candidates, there are 36 candidates, they got appointment as an untrained.
But their appointment goes.
No, state.
That is state. State is different thing, but their appointment was cancelled by the order of the coordinate bench, meaning thereby order of the single bench. Their appointment was cancelled, against which appeal was preferred, that was state.
Yes.
Now, if ultimately untrained candidates' right goes by virtue of the order to be passed by the Honorable Division Bench, is there any necessity to exercise, to make further judicial exercise in order to consider your respective right in connection with 2017?
Priyanka Noskar is all about aptitude test. Kindly see the Priyanka Noskar. Kindly see, madam, if my
So that's why court is of the view that why, for the sake of getting an order to go out of list, why this writ petition is filed?
because of that, my issue is completely different. Kindly visualize it.
That is no issue of wasting court's time. Let it go out of list. Let the matter be heard.
Yes. That is
But
the.
keep them interval.
Yes, it's obvious because coordinate bench passed the similar order. And my understand was.
Matter is heard when learned advocate